Hi, my name is Florence Paul, and this is Levelling With, the legal podcast with a difference. Over the coming weeks, I'll be bringing you some unique insights into the law, how it influences your life, how a legal perspective can enhance your business, and where legislation can help structure conversations concerning issues we face in society. In these first episodes, we'll be looking exclusively at the moments in your life where you'll need to consider engaging a legal professional and why.
So it actually pays to be more generous in that agreement, because it's still likely to be less generous than if there is no agreement at all. Because the courts will respect the autonomy of both parties.
Today I'm talking to Tom Quinn, a partner in our family team, about the wedding admin with the worst rep, the prenup. Last year it was found that 42% of marriages ended in divorce, but it's been found that prenups are not associated with a higher or lower chance of divorce. So why get one? And what really do they do? I sat Tom down to find out. First question, Tom, what is a prenup?
A prenuptial agreement is an agreement that parties who are about to get married or shortly to get married enter into, and the idea behind it is that it governs what will happen to their assets and so forth in the event that in the future they do end up getting divorced. The principal idea behind it is to avoid what can often be very acrimonious and costly litigation to determine a financial settlement on divorce. So you can sort of try to cover that as much as is possible. It's like an insurance policy basically. I think that's probably the best way of characterising it.
And are they enforceable in England and Wales?
No, they are not. That is a common misconception about prenuptial agreements in this country, in this jurisdiction. I know that in other jurisdictions, in other countries, they can be enforceable, but here they aren't enforceable as such, and the courts still have to undertake, technically speaking, their assessment of what is fair, and they have to take into account what are called the Section 25 factors. So they still have to look at the law, but provided the prenuptial agreement is properly entered into, and we'll touch on that a little later, then they ought to be not binding per se, but they will get enormous weight attached to them to the extent where, to all intents and purposes, they can be binding. Right. But they are, as I say, properly entered into, they are always going to be of high importance, if not magnetic importance, to the courts.
Okay. And what does make a prenup enforceable? What kind of process would somebody have to go through to ensure that it was afforded weight when it comes to financial?
Yeah, no, exactly. So there are several elements to this. Always very advisable for both parties to get legal advice, so they're both represented by different lawyers. It will have to be. They can't be represented by the same lawyer because they have different sort of interests. Effectively, yeah, that's right. There needs to be proper financial disclosure, so that, I suppose, looking at it from the perspective of the weaker financial party, and there's usually one. Sometimes they're both of a similar position, but usually there's one. They know effectively what they're signing up to and what they're potentially signing away. So if you don't fully disclose your financial position, then you could be in some difficulty down the line if there is a divorce, because the other party or your ex may say, well, I didn't know that he or she was worth this much money, and had I known, I wouldn't have agreed to the provision that was made in the agreement. So it's really very important to make sure that there is proper financial disclosure. Another big important factor is ensuring that the agreement is entered into and brought up well in advance of the wedding. It's always wise to mention it, I would say, months in advance, and certainly around the time of any engagement.
Okay.
I would never leave it last minute, and ultimately one wants to execute a prenuptial agreement usually they say about 28 days before the wedding or the civil partnership, as it may be. It's not technically required, but it's wise to. Why? Because it ensures that no parties seen to be or under undue pressure to sign up to it. It's like, if you place a prenuptial agreement before, and it does happen
the day before a wedding.
The day before a wedding, say sign so we're not getting married. Well, it's so late in the day, and often we receive instructions from people there is a temptation, I think, to bury your head in the sand.
Okay.
Because it's not an easy conversation necessarily to have. And that happens. And what that means is that people bury their head in the sand and they leave it very late in the day to enter into the agreement. I had one fairly recently where I think they'd be umming and ahhing about it, and the husband-to-be prepared a draft prenuptial agreement. I think it was given to my client less than 2 weeks before the wedding, and then I was subsequently instructed, and I had to tell her this is a non-starter.
No,
we can't do that. We can't do this now.
No.
They ultimately entered into a post-nuptial agreement, but yeah.
In terms of bringing up the possibility of having a prenuptial agreement, have you got any tips for having that conversation?
I think the easiest presentation for it is that it is an insurance policy. If things don't pan out, and it does happen, I don't know what the exact stats are, but it's, I think, is it up to 40% of marriages end in or civil partnerships end in divorce, something like that. So I think you can say, look, realistic, there is a possibility that we will go our separate ways at some point. I don't want it ever to be acrimonious, and I suggest that we enter into an agreement, a prenuptial agreement to govern this, and basically as an insurance policy, should something go wrong. Sometimes it's much easier, I think, where there's been a divorce before for either of the parties, because you can say, I've been through this before, it was horrendous. It's never easy anyway, is my understanding from my lawyer at that time, and I've been advised, and I would like to enter into a prenup just in case. And it's quite a grown-up way of dealing with things, and just looking at what might happen. No one wants to think about it. It's like saying no one wants to think about dying in the future, but people get life insurance. So I think it's still not an easy conversation, and the process itself it's not a perfect thing to go through before a divorce, before a marriage rather. All the more reason, I think, to try and do it way in advance, because you don't want thoughts of financial division and so forth, a couple of weeks or 3 or 4 weeks.
Not very romantic, is it?
It's not particularly romantic.
No.
They aren't romantic things.
No. You mentioned a post-nuptial agreement for your client that you had recently. Can you just briefly explain what a post-nuptial agreement is and when you'd expect to see one?
Sure. A post-nuptial agreement is the same as a prenuptial agreement. It just occurs after the marriage or civil partnership. Post-nuptial agreements can come about in several circumstances, that being one of them. The risk with post-nuptial agreements, where there is no preceding prenuptial agreement, is that no one's duty-bound, no one has to enter into it, and you can't impose a post-nuptial agreement on someone. So it's almost like the horse has bolted. There is the risk that your spouse, who would be the recipient of the draft agreement, and in all likelihood the weaker financial party, might turn around and say, no, I'm not prepared to enter into this. Or there can be also, because there's no time pressure there can be really rather protracted negotiations sometimes. So it's a bit risky in that regard. Post-nuptial agreements also crop up in circumstances where there has been a prenuptial agreement, and what you usually get in prenuptial agreements is a review clause where that agreement will be reviewed in certain circumstances.
Right.
The key ones are after a certain passage of time, such as 5-10 years, something like that, or their children are born.
Yeah, I was going to say
there's been
children.
some other huge change or significant change in circumstance. Otherwise, it might be that for estate planning in relation to a couple that perhaps have got married many years ago, and parents of one of those parties is now looking to do some estate planning or something, and wants to gift monies or a business perhaps or whatever it might be to their child, they may want to do it on condition of there being a post-nuptial agreement, and that agreement might seek to carve out any assets to be received should there be a divorce in the future.
Yeah.
Does that make sense?
Yeah, absolutely. So in terms of review clauses within a prenuptial agreement, you're talking in terms of when you enter into the agreement having a financially weaker and a financially stronger party. Is the prenup drafted on the basis of that will always be the case, or are there provisions that will say, if the financial situation changes, perhaps because of maternity leave or somebody makes millions in some business venture, would you then review that, or would the existing prenup still stand? How does it change when?
The difficulty with those review clauses, and nobody has a particularly great appetite to review a prenuptial agreement, number one, or the agreement. Number two, whilst you can do that, it's quite tricky to impose. You can't actually impose any change in that, any proposed change in an agreement on either party necessarily. Mm-hmm. So it is quite difficult. And I have to say, I'm trying to think if I have actually ever had one yet. I have a couple, actually, funnily enough, on the books at the moment. One of them is an agreement, a prenuptial agreement was done. My client, who was the financially stronger party, is looking at reviewing it potentially because he's coming into more assets from his father. And I'm actually thinking about how best to do that, because one of the difficulties we have is that this prenuptial agreement, which I hadn't drafted actually, probably didn't make great provision for his wife in any event, still less now that he's going to be inherited or
even wealthier.
Being gifted. Yeah, going to become significantly wealthier. So it would be wise for him to look at reviewing that upwards for his wife, because in the event, so prenuptial agreements can be challenged, or they can always be challenged, but where there's strength to a challenge conceivably is where the agreement is, there's no easy way of saying it, a bit tight.
Right. Unequal.
Yeah, exactly. If you don't make sufficient provision, technically it's if you leave the weaker spouse in a predicament of need or real need, and that's quite an elastic concept, it has to be said, then they can challenge the agreement and say, look, this agreement hasn't made sufficient provision for me and I wish to challenge it. So you want to avoid that if you can. So it actually pays to be more generous in that agreement, because it's still likely to be less generous than if there is no agreement at all, because the courts will respect the autonomy of both parties. Say, well, you reached this agreement, it was entered into properly, and I can see that it may not be all that you hoped for, but it doesn't leave you in a predicament of need, and therefore you ought to be held to.
Yeah.
There we are.
Yeah. Okay. What do you think people should think about if they are considering drawing up a prenup? How specific should one be? What kind of content would you expect to see? Is it general, we're going to split all assets 20-80 or something more? That
really does depend on the circumstances of the case. But one thing I tend to advise most clients is to leave anything relating to children out of it. It's much easier to just deal with that separately at the time, because A, they may not have children at the time that they entered into the agreement, and B, these agreements necessarily require quite a degree of crystal ball gazing. And it's usually the case that whilst there may be disagreement about financial elements relating directly to the parties, when it comes to children, not always, sadly, but most of the time, parties tend to be, broadly speaking, on the same page in terms of, school fees, for instance, levels of child maintenance. There can be a bit of a dispute there, but they tend to be okay on that front. So my stock advice there tends to be to leave that out of it if you can. It may inform housing. The key things you've got to think about are housing, I think, really, and then maintenance, spousal maintenance, if at all, and how we can structure that. And it also depends how liquid the parties are, how much money they have at their disposal now, and what assets they intend to, how they intend to deal with assets that are acquired during the marriage. Are they going to be held separately still? Are they going to be held jointly? My advice is it makes matters easier if anything that's acquired during the marriage is joint to some extent.
Right.
And yeah, those are some of the key points. When you're dealing with massive wealth, when I say that, I tend to mean clients with hundreds of millions or very, very many, the high tens of millions of pounds. It's not attractive, but the simplest way of dealing with it is to sort of have a tariff, basically, which goes something like, for each year of the marriage or each period of the marriage, every 3 to 5 years or something, an additional sum of money goes to the other spouse. There's something. It tends to be more straightforward when it comes to housing, but that's a simpler way of doing it. It can be seen as a bit crude, but
yeah, a little bit crude. Do you recommend them only for people that have very high net worth, or is it something that anyone entering a marriage should consider?
If I have someone come to see me, the short answer is most people nowadays, from middle to upper middle class upwards, I would say it's worth having a think about, definitely. And we would always be happy to have a conversation with anybody about that. And it's certainly not so. If I were to conclude, I don't think it's sensible. I don't think it's worthwhile entering into a prenup for whatever reason it might be. Maybe there aren't enough assets, and there never will be, or that's unlikely to be, and it would therefore be too speculative, and therefore the cost just isn't worth it. Then I would never charge for that. I'm happy to have that conversation with anybody. In terms of, but more broadly, because the cost of them is relatively modest, and I think, you can budget for less than, you have to pay for 2 sets of lawyers, accept that. You can look at, and obviously it will depend on the complexity, which is often tied to the scale of the assets in the case. But if you're talking about a basic prenuptial agreement, you can, which can end up costing anywhere between 3 and 5 grand. It can go a lot higher than that, except 3 to 5 grand plus VAT, and you've got the same, or if maybe slightly less on the other side as well. You're looking at about 10k potentially. That's not a huge
in the grand scheme of things.
Cost in the grand scheme of things as a one-off insurance policy potentially, when weighted against the cost of litigation in the future where there isn't one, which can be tens and tens and tens of thousands, if not hundreds of thousands of pounds. So it's always worth thinking about, I think. And as I say, we're happy to have conversations with people to see the feasibility, to assess the feasibility of it. It isn't always feasible. I have had people approach me before, and I said, I don't think this is worth your while.
Just because of the level of wealth.
Because of the level of wealth, often because it's just highly speculative, and you're like, well, if the clients have nothing now, and they may do in the future, the way it's likely to be governed by the law is you're going to split everything equally anyway. And if they're relaxed about that, well, what's the point? And if there's no wealthy parent or benefactors or relative that's going to give them huge wealth in the future, which is a different point, obviously, then there's probably no point to it.
When interpreting a prenup, or when looking at a prenup, would the courts look at the circumstances that they were in when they entered the prenup, and then say it's 20 years have passed and one party's made millions, when they're considering how to implement that?
Yeah. So the passage of time can make a prenup more fuzzy because, as I said earlier, when you're drafting a prenuptial agreement, when you're considering what financial provision or the structure of financial provision to be included into that agreement, there is crystal ball gazing. And obviously that's going to be less accurate in all likelihood the longer the marriage goes on. So yes, the courts will they have to look at what was the position at the time they entered into this agreement, what has been said about their wealth, their respective financial positions at that time, to include any predictions as to what the future might look at. So there are schedules in a prenuptial agreement which put each party's financial disclosure in, and often there's a disclosure for joint wealth as well. And there you will put, do you have any future inheritance or other wealth expectations? And so it's important to include that there. but there might be something that's completely unforeseen. And if it's significant, really significant, and if looking at the provision under that prenuptial agreement, there's such a huge disparity and weighted against also their standard of living now, then it might be that one has to, that's going to intrude on the provision in the agreement.
And do you expect that would come down to needs?
Yeah, I would. I always, the existence of the agreement would have a dampening effect, I think, on the claims of the weaker party, provided it's properly entered into, as we discussed earlier. That'll always be the case. So even if they can't reach agreement, so if they're looking at not tearing up the agreement but revisiting it, they can't reach an agreement, so they go to court. I would have thought that whatever provision is made is still very likely to be much less or significant or materially less than if the agreement wasn't in place. And often there are terms in the agreement that govern what happens with, huge wealth that is generated. But if it's completely out of the blue or completely out of proportion positively vis-a-vis the assets and the expected assets at the time the agreement is entered into, then there's likely to be a revisiting of it to some extent, and a court saying, well, this is just not fair now. But let's be honest, it's a nice problem to have, right? Because it's like paying a lot of tax. You pay a lot of tax, you've made a lot of money. So it's sort of a similar principle, I guess.
And how's it accepted by clients if you're saying to them, you need to make this prenup fairer on the financially weaker party?
Well, the way you present it to them to clients is, if you're too tight, this agreement isn't going to have as much weight. I wouldn't put it quite like that. I wouldn't say catch my clients being tight, although they are sometimes, but they can. Anybody can be. The more generous you are, the more likely this agreement is never really going to be revisited, or can't be challenged, or the challenge to it is very limited. So it pays to pay, basically. It just does. I've acted on challenging prenups before, and when I'm presented with an agreement, fortunately thus far not one that I've drafted, that is really particularly tight, I like it because it means the court's probably not going to pay much attention to it. Also, it's pejorative. It paints the other party in a poorer light, frankly. So having quite a lot of negotiations between lawyers as to the provision in the agreement coming up shows a pattern of a considered agreement being entered into where real thought has gone in, particularly as regards to need and so on. And so it's going to have great weight attached to it. Mm-hmm. And so I like to do that. And it doesn't always. Sometimes you don't need to, and clients tend to be very willing to listen because they just don't want. The whole point is to avoid litigation. You can't get, unfortunately, because at the moment with the law as it is, you can't guarantee that. But the next best thing is to say, look, this is going to get as much weight as is conceivable to an agreement as the law currently stands. It's the best you can do. So yeah.
And do you account for assets in other jurisdictions in the same way in a prenup, or is there something slightly more specific that needs to be done?
No, it's the same thing. It's all disclosed, and it's the same principle as if there's a divorce with no prenup. If there are foreign assets, they are dealt with in the divorce, in the settlement or distribution of assets, and it's precisely the same principle. What might happen, I suppose, is that if there are a lot of foreign assets and it's an international family and there's a potential possibly, therefore, that they might move globetrot or whatever, or live in that other country or other countries. So quite often what you have to look at with international couples or families is getting advice in other jurisdictions to see either what you need to do to your agreement to lend it the appropriate weight should the divorce take place in that jurisdiction at a later date, or possibly enter into a mirror agreement. I mean, it's all costly, but if they've got significant assets all over the world, hopefully it's affordable. Fine, yeah.
And the level of disclosure that's required pre-drafting a prenup, is that similar to what you'd find in a financial settlement through divorce, or is it less disclosure?
It doesn't need to be as precise or as particularised. So, for instance, if you're going for a divorce, you have to complete a big 30-page document called a Form E. You have to append years of bank statements. Property valuations are required. Business valuations are required. You don't need to do that. You need to disclose everything, and you need to have clarity on figures as much as possible, or values. You don't want to underplay anything. It's better not to overstate anything either, but if anything, you err on, it's looking this big. So what you want to do is ensure that the weaker financial party has a clear understanding of the scale of wealth that's there, or the scale of assets that are there or are expected to be there in the future, as much as it's possible to know that. For instance, if there are wealthy parents involved that are likely to gift their child assets, and often they can be a driver for the prenuptial agreement as well. So I don't want, if there's a divorce, or
if you're marrying that person,
exactly,
then
or your brother's got divorced twice already, and he's that sort of thing. We want to make sure we don't lose everything on a divorce. Don't want to sound too cynical, but it does happen.
Yeah.
Likelihood is you won't know what you're going to inherit, but you know that it's going to be hundreds of thousands or tens of millions or millions or something, and you just put a figure. You just put a little descriptive point on that in. I don't bother with. I don't advise clients that there's a need to provide documentary evidence backing up their financial disclosure, because why would you make anything up? It's not gonna help you. So you don't need to do that. It's usually a schedule. It can be a couple of pages long, usually, just sort of a summary of what's there.
What advice would you give if you were advising a much weaker financial party in drafting a prenup?
So I think the big one is just having a detailed look at worst case scenario and what they're going to be left with. We always want to make sure that my clients, where we're on the other side of it, where my clients' needs are going to be met comfortably, and there could be no uncertainty there. Where there is uncertainty, there's the ability potentially for that to be a discrete item that needs to be arbitrated on or considered by the courts or by an arbitrator, usually.
In the same way that any other matter would in financial proceedings.
Exactly, but you try to limit the areas where there might be discussion. It might be, for instance, also maintenance. Is there going to be spousal maintenance? It may not be possible to establish now whether or not that's going to be required. And another thing I like to do where possible is where wealth is built up during the marriage, try not to keep that separate to the parties. Try and make everything that's built up during the marriage joint as much as possible. Often that's difficult because that's what the other party might be trying to avoid, particularly if there is wealth being gifted or inherited. And there has to be some respect for that as well. Even when you're acting for the weaker party, like, well, that's coming from parents above and that's what they're wanting to do, and I can see that you're going to be fine, so that should be okay. The worst case scenario is that you say, I can't advise you to enter into this agreement. It's too tight. It leaves you very exposed. Whilst there's a good chance that the courts may invade or intrude on that agreement because it's left you in a predicament of need, it's uncertain. It's just not worth it.
No. Okay. And would you advise someone like me to get a prenup? Not that you know anything about my financial circumstances.
It's quite difficult to answer. But you don't have to tell me too much either. It's really tough with young professionals. If there are two young professionals who are starting out completely afresh, who perhaps don't have much money behind them, or if they do, it's very modest. Maybe a parent's going to give them enough. One of them will give them enough for a deposit or something like that, and there's nothing much anticipated really in the future of any huge significance. It's so uncertain. Those are the situations where I tend not to see a huge amount of point. If there's one party is likely to earn massively, and they want a prenup, again, it's tricky. So young professionals is a challenge unless there's inherited wealth that one of them is wanting to, or future gifted wealth or something that they're going to receive in the future that needs to be carved out. That's fine as far as it goes, provided they make money in the future. If they don't, the likelihood is that some of that money will have to come into the equation. But those can be tricky ones, and they tend to be, for me, not particularly worthwhile unless that's the case. But then you're looking at quite a significant outlay.
Hopefully. Cool. One more. What is the biggest mistake that people make when drafting a prenup?
Yeah, easy. That's being too tight, provision being too low. Because no one wants a prenup to come back to you to be and being challenged. That's something it hasn't happened to me yet, but I know it's happened to other people, and it's a stress when your homework's effectively being marked again. That's the most common mistake that's made, I think, is just making the provision in them too low, and therefore them ending up with not having that much weight attached to them.
Good answer, I like it. Me again. Thanks for listening to this episode of Levelling With. Next time, I'll be chatting to Olivia Toulson, and we'll be discussing becoming a parent, what your rights are when this happens, and the process of navigating the workplace during this time. Remember to rate us on your app of choice for podcasts. And if you like this episode, why not subscribe? We're available across Spotify, Apple Podcasts, and Google Play. Also, follow us on social media. We are at Birketts LLP on Instagram, LinkedIn, X, Facebook, and TikTok.